Good morning. Thank you for joining the Litigation in 2021 webinar. My name is David Fielder and I'm the Commercial Clerk here at 3PB. We have over 500 people signed up to attend this morning's webinar. So we're just going to allow a couple of minutes for people to join and then we'll begin. Thank you.
Thank you, David. My name is David Berkley and I have the privilege of being Head of Chambers here at 3PB Barristers. Those of you that are joining us and those who are now coming through, we're about to spend this webinar devoted to matters that are very timely. I can tell you that lockdown has affected us all in different ways. I had the opportunity over lockdown to read Daniel Defoe's book, A Journal of the Plague Year, which he published in 1722, which describes the London epidemic of 1655. And he describes how the Inns of Court were shut up and the lawyers weren't to be seen. Well, 300 years on, and by contrast, we've not been idle during this pandemic. I think that we've learned new skills, we've reached out to new markets, and I'm delighted to say that we, as one of the largest sets in the country, 6 sites, over 200 barristers, that in every respect we've met all our targets. And a lot of that comes from our relationship with you and from the people whose services we provide services to. And today we've got the opportunity to showcase 2 members of Chambers who are going to demonstrate their expertise and particularly in the matters that we are now concerned with within the current coming out of the lockdown and seeing the easing. The first person to present today is going to be Richard Whitehouse. And Richard is a Chancery Commercial and Professional Risk Barrister. Before he came to us, he was a solicitor advocate and head of a commercial dispute resolution in a large firm of solicitors in Bristol. Since coming to us, he has specialized in commercial dispute resolution and is a very highly regarded litigator, negotiator, and advocate. So I'm going to hand over to Richard in a moment. Can I just draw your attention to the following matters of housekeeping? First of all, we do welcome comments and questions, and you can do that by posting them to the chat, which you should be able to find within the interface. Secondly, there's going to be an opportunity for us, I hope at the very end, after both of the talks, to come and be able to deal with some of those questions, probably not all of them. And then finally, can I point out that, that these presentations, we are going to provide all those who've attended with copies of the slides and the notes, which we'll hope to post out to you later today. So without further ado, I'm delighted to call upon Richard Whitehouse to talk about civil litigation post-Brexit.
Good morning, everyone. Hopefully you can hear me and see me okay. I'm just going to share my screen. There we are. So welcome to this talk on civil litigation post-Brexit. Thank you very much, everyone, for attending. I hope to be able to address some of the key issues arising from the situation after we've left the European Union. It's obviously a very large area with a lot to consider. One warning right at the outset, it's probably not an area for the faint-hearted. This is an area that's contains now a huge variety of instruments. The structure of the changes now requires, to some extent, knowledge of what the position was before the UK's accession to the EU. And to make things even more difficult, we're still subject to some changes. And the most significant one is in relation to the 2007 Lugano Convention, So we've had a question prior to the talk about this already, and I will address that, as we said, at the end of the talk. But we were hoping that by this time in April, we may have had a more concrete idea of what the position would be regarding the Lugano Convention, because it will make things much more straightforward in terms of jurisdiction, recognition and enforcement of judgments. But for the moment, the UK hasn't joined that, so I'm going to be addressing the position as it is right now. I hope to steer a course in this talk between not being too detailed, but identifying what the law is and where to find it. As we've said, there's a very detailed handout that will come out to you afterwards with lots of helpful references. So to start with a very brief chronology, it's very helpful to keep in mind the key dates. And for the purposes of this talk, there's two key dates. There's the 31st of January 2020, when the UK left on the terms of the withdrawal agreement, then entered into a transition period, which ended at 11 p.m. on the 31st of December 2020. So that's known as, in the legislation, the IP completion date. And it's from that point on that I'm going to focus on in this talk. The position during the transition period was generally that the position was the same for the UK as when it was a EU member. So to briefly run through the agenda, it's split into three sections, this talk. First, we're going to be looking at the European Union Withdrawal Act 2018 itself. It's been amended obviously by the 2020 Act, and we'll look at how that operates. Then we're going to look briefly at the sources of the new law, particularly the ongoing status of retained EU law. And then the main focus of this talk, because I thought it would be most helpful, will be on the impact on civil litigation. So focusing on jurisdiction, applicable law, service and enforcement. And it's important to remember at the outset that we need to consider the position both from the UK's perspective and the EU's perspective. So in some of the EU regulations, the UK now becomes a third country. So we need to make sure we're aware of that, that difference in those two perspectives. So that's enough of an introduction. Let's get into the talk. So as I said, we're starting off with the structure of the 2018 Act. And I've set out there 3 bullet points, which are, for our purposes, the most important sections. And we're looking here at essentially what the law is and what law still applies. So the Act starts off with the repeal of the European Communities Act 1972 in section 1. And the reason that that's so important is that that 1972 Act has been described as a conduit pipe that implemented and gave precedence to EU law. So with that gone, the question then is what remains, what's left and what applies. And that's dealt with in sections 2 to 7. By transplanting what's referred to as retained EU law, and we'll look at that and what that means in a bit more detail. That's transplanted into domestic law. So I found it helpful actually looking at those sections. It's quite clearly set out within the Act what the retained EU law is. So if you have a question regarding this, I think the first port of call would be those sections. There's then the rulemaking power for dealing with deficiencies arising from withdrawal in section 8. So there is a modification power, but it has some strict limits. It basically applies where EU law has no practical application to the UK and is effectively redundant. So if we move on now to the sources of the new law, there's three main sources set out there. I want to focus on the first one, which is essentially the retained EU law, as I mentioned previously. And that's the law as it stood at the IP completion date. And it's effectively a snapshot at that fixed point in time, so the 31st of December 2020, of the EU law that we've taken and transplanted into our domestic law. And that's made up, that law, of three main areas. The first is EU-derived legislation, so domestic legislation that gave effect to EU directives. So things like the Health and Safety at Work Act 1974. Secondly, there's direct EU legislation that didn't require transposition. So that would be things like, if they hadn't been specifically revoked, things like the recast Brussels regulation. And then thirdly and finally, for our purposes, the EU case law. So all of those things apply so far as they were operative immediately before the IP completion day, exit day. And they form part of domestic law on and after the completion day. And the UK's are now not bound by future EU law decisions of the European Court of Justice. Section 5 of the Act specifically sets out that the supremacy of future EU law is removed. And Section 6 in relation to case law says that the UK courts may have regard to future EU case law. So that's created some uncertainty, and that's the key phrase to keep in mind. That's taken from the legislation, have regard to future EU case law. And as I say, there have been some questions about what that means or what that's likely to mean for future cases. One way of looking at it might be to that the UK court will react in a similar way to the way it does to Commonwealth cases. And a cautious conclusion might be that EU case law is persuasive. It'll be followed for consistency unless there's a reason not to follow it. So, as I say, that retained EU law is the most important part of the sources of new law. There are those other sources, but they're not particularly relevant for our purposes today. So, as I said, I wanted to focus on the more practical procedural aspects of the changes and the impact on civil litigation. And I'm going to consider four areas set out there. Firstly, jurisdiction, the applicable law, service, and recognition and enforcement of judgments. So we're looking at, obviously, cross-border litigation, the withdrawal agreement, the international treaty, and the 2018 Act, which puts that into domestic effect, don't really deal with these procedural matters in much detail. They have transitional provisions, and there's provisions in relation to related proceedings. So if you've already issued a claim and there's a very similar related proceedings, they can be brought within the old rules. But otherwise, we're left in a position regarding these procedural aspects, falling back on international conventions and common law. So to look at that in a bit more detail and moving on to the first issue of jurisdiction, the issue here we're looking at is essentially where you've got a dispute between a UK buyer and a French seller, and both issue in their own courts. You've got those parallel proceedings and a dispute about jurisdiction. And the two issues that arise from that are, when will the UK accept jurisdiction, and when will what will member states do if a related action is brought. So previously, when you had such jurisdictional conflicts, you would be looking at the recast Brussels regulation, or the 2007 Lugano Convention that we've mentioned that applies to the European Free Trade Association countries, so including Norway, Iceland and Switzerland. And the aim of that, or those regulations, was to provide certainty and predictability. And the reason for the change is that it was thought that those regulations depended on reciprocity, so the mutual cooperation of states. So, for example, if you look at Article 27 of the recast Brussels regulation, where you've got an exclusive jurisdiction agreement and the claims issued in that member state and also another one, the other state is required to automatically decline jurisdiction, or in other circumstances where there's not an exclusive jurisdiction agreement, you can have a stay in the other state where the claim's been issued. So there's that neutrality there that it was thought was a reason why the Brussels and regulations in the Lugano Convention couldn't continue to apply. So those have both been revoked. And there's nothing at the moment, subject to the position regarding the Lugano Convention, to take their place. And just one reminder that although they've been revoked for UK purposes, for the EU member states, they will continue to apply the recast Brussels regulations where they apply to the UK as a third-party state. And they will also apply their national laws where they're relevant. So, as I say, you fall back on the common law unless you can fall within some particular provisions. And those provisions are set out on the second and third bullet points on the slide. The first is regarding consumer and employment contracts. You'll be in a much clearer position if you're dealing with a case regarding those. Looking at section 15 of the Civil Jurisdiction and Judgments Act. So for a consumer contract, if the consumer's domiciled in the UK, the courts of that part of the UK will have jurisdiction, and that simplifies things. The other exception is the 2005 Hague Convention, and I've said there NB limitations. So it's there are some significant limitations to its application. Generally, it demands that courts of the contracting state give effect to exclusive jurisdiction clauses. It has force of law in the UK. The Civil Jurisdiction and Judgments Act 1982, section 3D, provides for that, and it has effect from the IP completion day. It sets up a scheme of reciprocal duties and a similar one for enforcement and recognition of judgments as well. But as I say, the scope is limited, and there are four ways in which it's limited. The first, and probably the most obvious one, is the system works between contracting states. So both states need to be signatories, and the contracting states are the member states of the EU, Mexico, Singapore, and Montenegro. So that's your first thing to consider. The second limitation, and a very important point to consider, is that it only applies to certain subject matter. So it's really focused on commercial disputes. The subject matter is limited in Article 2, and it sets out quite a number of areas that it doesn't apply to. So, for example, it doesn't apply to contracts with consumers, employment contracts, insolvency and analogous matters, or carriage of passenger of goods. So they're quite significant limitations, and it's worth checking Article 2 if you are hoping to get within the Hague Convention. The third area of limitation is that it only applies to exclusive choice of court agreements, so not to any other kind of jurisdiction clause. So where you have non-exclusive agreement or asymmetric agreement, it won't apply in those circumstances. And the final limitation, and again this one creates some uncertainty, the date of the agreement that it applies to. So it only applies to agreements concluded after entry into force in the state of the chosen court. So the EU is adopting the position that that's the 1st of January 2021. So you need a choice of court agreement after that date. But one point to bear in mind and might be useful is that choice of court agreements can operate separately from the substantive contract that's set out in Article 3D. So in relation to older contracts, and hopefully this won't be too relevant if we've only got a few weeks until we know about Lugano, but if we don't join that, then it may be relevant going further forwards. But with older contracts, it might be worth having a kind of supplementary choice of court agreement if you think something is going to happen urgently or there's a high litigation risk. So as I said, otherwise, if you can't fall within those specific provisions, you're left with the common law principles. They're reflected in CPR 6 and specifically the practice direction 6B. So the common law rules mainly founded on service or submission to the jurisdiction by the defendants. You've got the jurisdictional gateways and the court's jurisdiction. So you'd be essentially in the same position as you would with other foreign countries that we've dealt with jurisdictional issues previously. So one of the main differences is rather than looking at where the defendant's domiciled, as you would previously under the regulations, you'll be looking at the connection to the UK and establishing that England is clearly and appropriately the forum for the trial, and that you satisfy the court's discretion. So you're looking at, in terms of connection, if it's a contract matter, things like where the contract was entered into, where it was breached, where the witnesses are, where the evidence coming from, and all of those types of matters. So that creates much more uncertainty and probably for clients additional cost as well. So that's the summary in relation to jurisdictional issues as it stands at the moment. Now I want to move on to the applicable law. And the good news here is that there's far less change. It's much more straightforward. Rome 1 for contractual claims and Rome 2 for non-contractual claims continue to apply. They've been transplanted into domestic law with very minor amendments. Those minor amendments basically relate to terminology. So rather than the UK being a member state's been replaced with relevant state, effectively changes to make sure that it operates effectively in domestic law. And there was less change in this regard because it's thought that rather than there being mutual obligations and reciprocity, it's thought that the Rome 1 and Rome 2 have universal application. So they apply whether or not the laws identified. So relatively straightforward in relation to the applicable law. EU courts will continue to give effect to the governing law clauses, the law chosen by the parties. So if we now move on to service, the two main issues that arise here are, do you need to obtain permission to serve a claim in the EU? And what's the mechanism or procedure for effecting service? So previously, we would have been looking at CPR 6.33. And that was drafted so that permission wasn't needed if there was jurisdiction under the recast Brussels regulation or Lugano. The significant change is that CPR 6.33 has been redrafted. It's been amended so permission isn't required in 3 types of situation, and they're set out on the slide. So the consumer and employment claims under the Civil Jurisdiction and Judgments Act 1982. And secondly, under 2005 Hague Convention claims. And thirdly, and this is a very recent amendment on the 6th of April 2021, the CPR was updated so that where there's a jurisdiction agreement, the permission isn't required in those circumstances either. So it states that a contract contains a term to the effect that the court shall have jurisdiction to determine the claim. So it's outside the Hague Convention, but where the English courts have jurisdiction, permission's not required. Then in relation to the second issue that I mentioned, the procedural point, the EU service regulation and the EU taking of evidence regulations have both been revoked. So now you need to look at the Hague Service Convention. This isn't new. Most trading partners are contracting states. I've had a case recently where we've served in the US and that's applied in those circumstances. The Hague Service Convention website is actually very helpful. It has a list of the contracting states and further information about it. So not a huge amount of change there in terms of the actual procedure, and those familiar with serving in other jurisdictions will be familiar with those rules. So the final area of the procedural issues that I wanted to address, recognition and enforcement of judgments. Obviously, until now, we've been looking at the recast Brussels regulation and Lugano. So it's similar to the jurisdictional issues. And there was a system essentially where judgments and the enforcement and recognition of them was pretty much automatically recognized in another state bound by those conventions. As we've said, both have been revoked, but there is an important point here regarding the transitional provisions under the withdrawal agreement, and specifically Article 67. Based on the commencement date of the proceedings. So if you've already issued a claim against a defendant in, say, Spain in November 2020, and the trial's not until November 2021, for example, Spain will apply the recast Brussels regulation in relation to recognition and enforcement of judgment in those circumstances. So you have that transitional provision, which is useful to remember. Otherwise, you're looking at a similar situation regarding jurisdiction, looking at whether you can fall within the 2005 Hague Convention. It's got its own regime. It's generally very useful for enforcing and recognising judgments. There's generally no review on the merits. There's limited scope for refusal by other contracting states, and the registered court is bound by the facts of the court in which the judgment was obtained. If you can't fall within the Hague Convention for the reasons I set out previously, those significant limitations, you're looking at bilateral agreements with individual states, and there are a number of these. They were incorporated into English law under the Foreign Judgments Reciprocal Enforcement Act 1933. And so they are from, well, with France, 1934, and then a number from the 1960s. So the countries they apply or potentially apply to are Austria, Belgium, France, Germany, Italy, Norway, and the Netherlands. There's some uncertainty about whether they continue to apply because they've obviously been superseded by the EU rules in the intervening period. So it's worth checking those. I know in relation to Norway, Norway's committed to the continuation of that applying, obviously in the absence of Lugano. And then if you can't fall within the Hague Convention, a bilateral agreement, you're looking at the common law principles, and common law in relation to recognition and enforcement of judgments would require you bringing an action on the judgment. So I think I've pretty much got to the end of my time. The final slide is just a brief conclusion. The process of identifying the law is significantly more complex. We're looking at international conventions and common law rules. There may be further changes to be aware of. And as I mentioned during the talk, it may be necessary to consider new jurisdiction choice of law clauses in contracts and potentially other dispute resolution clauses. I know a number of parties are looking at arbitration and mediation rather than entering into these types of issues. So that concludes my talk. I hope that was helpful, and we will deal with questions at the end. Thank you.
Thank you very much indeed, Richard, and thank you for that. And as we said, there will be opportunity to answer some of your questions at the end. There are over 300 of you participating as attendances at this web seminar. That's absolutely brilliant. There's some very familiar faces and names, and many of you are newcomers, but you're all very welcome indeed. We're now going to turn to Jack Webb, and Jack specializes in real property and commercial law here at 3PB. He's got a first-class honours law degree from my alma mater, Manchester University, and he has a growing reputation for his advocacy skills. And he's going to be talking to us now. Again, you'll have the opportunity to put questions, post them to the chat, and we'll try and answer as many of them as possible when we can. So let's hear about about the COVID and the courts from Jack Webb. Over to you, Jack.
Thank you very much, David, and good morning all. I'm going to attempt to share my screen. There we are. As David's indicated, my discussion is a sort of general case update on COVID and the courts. I'll be looking at 3 High Court decisions, all hot off the press for 2021, and all dealing with how the High Court will approach applications to extend time, to adjourn, or to excuse non-compliance said to arise as a result of the pandemic. These are the 3 cases. In addition to being decisions of the High Court, they are mercifully also all rather short. Copies of the cases will be distributed at the conclusion of today's talk. And starting things today is a decision by Sir William Blair, sitting as a High Court judge in the case of VTB Bank and Medj And I start with a warning, indeed, Sir William Blair's warning. The factual background to this dispute is rather dense. It relates to a $280 million loan and share pledge agreement to facilitate copper mining in Armenia. Fortunately, we don't need to get into all of that today. For our purposes, the relevant facts are these. VTB Bank sought an anti-suit injunction to prevent Mr. Medj from continuing a set of proceedings he had issued in Armenia. The basis of that anti-suit injunction was a London arbitration clause that was part of the loan and share pledge agreement I had referred to just a moment ago. That injunction was sought without notice, and on the 22nd of February 2021, directions were given for the filing of evidence and the listing of a hearing. Mr. Medgler-Mine sought extensions of the deadline to file evidence and also sought an adjournment of the listed hearing. How then does COVID enter the frame? Well, Mr. Medgler-Mine's solicitors put in a witness statement to the effect that Mr. Medgler-Mine was suffering from COVID-19 and as a result had not been able to provide meaningful instructions to them. And absolutely crucially for our purposes today, Mr. Medgler-Mine's solicitor also included a medical report confirming that Mr. Medgler-Mine was incapacitated by COVID and would be for a period of 1 month. What did VTB Bank have to say? Well, they've raised a number of familiar arguments that will be familiar to those of you who have dealt with applications like this before, of which I'm sure there are many. Firstly and foremostly, they argued that Mr. Medgler-Mine had had ample time to gather his evidence and that there was no reason for a deadline being extended. And here dates do become relevant. It was the 23rd of February 2021 that Mr. Medgler-Mine knew evidence was due to be filed and knew that the deadline for filing evidence was the 10th of March 2021. Medical report that had been exhibited suggested that Mr. Medgler-Mine had contracted COVID on the 5th of March 2021. And so in consequence, there were several weeks between the 23rd of February and the 10th of March in which Mr. Medgler-Mine ought to have got his house in order. That was argument one. Dovetailing from that, argument two was that Mr. Medgler-Mine had had ample time to bring this application. And it's worth pointing out that the application was brought on the 10th of March 2021, which it will be recalled was the final date for the filing of evidence. And finally, there were familiar arguments as to prejudice arising as a result of an adjournment. And interestingly, in this case, and it's not properly explained, VTB Bank had somehow come to the conclusion that if the matter didn't proceed on the listed date of the 23rd of March 2021, the next available date would not be until sometime in October. So familiar arguments, as I say, and reading the judgment, I have to say I felt somewhat pessimistic about Mr. Medgler-Mine's chances. I was wrong. Sir William Blair did note that there was force in the submissions on delay, but as can be seen highlighted here, accepted without hesitation the arguments put forward by Mr. Medgler-Mine because they were supported by entirely credible medical evidence. And what can we deduce from all of that? Well, firstly, evidence is crucial. It seems to me that Mr. Medgler-Mine owes a great debt to his solicitors. The presence of a medical report was central to Sir William Blair's decision. And I suspect things would have gone quite differently indeed had Mr. Medgler-Mine not been able to produce one. The take-home message, of course, is that if you are seeking an adjournment on the basis of your client's COVID-19 illness, you must put in medical evidence. And if you are opposing such an application, you must point out deficiencies in that evidence. So that's the first crucial take-home. The second is that evidently Sir William Blair thought that there was some force in the point on delay. And you must ask yourself whether you're too late to seek the court's indulgence. Now, clearly there was not enough force in this point to defeat the presence of the medical report, but it seems to me that Sir William Blair had nonetheless given a clear is not so much a lesson, but more a trite reminder that you must make your applications as soon as you possibly can. And finally, indulgence. Are you asking the court for too much? What I haven't mentioned is that Mr. Medgler-Mine sought a modest 21-day extension for the filing of evidence and an adjournment to the first available date thereafter. And I suspect that this would have been a very different decision indeed if Mr. Medgler-Mine had not sought a 3-week extension, but had in fact sought a 3-month extension. So a heavy emphasis on medical evidence and an indication that the court will not allow reference to coronavirus alone as excusing all failings. And with that in mind, we proceed to the second case, Ashford Borough Council. This concerned one Mr. Wilson, who, if you don't know, is a wealthy buy-to-let owner. And since 2011, it was alleged that he had engaged in a campaign of harassment against Ashford Borough Council. And for those seeking a bit of light lunchtime reading, this has been reported heavily in the press. Ashford eventually issued Part 8 proceedings to restrain this alleged campaign of harassment, and a trial came to be listed for January 2021. At that point, Mr. Wilson, quote unquote, applied for an adjournment. The reason I use air quotes is because in reality, he requested an adjournment within a witness statement. That matter came before Mrs. Justice Stein, who rejected his air quotes application. And shortly thereafter, incredibly so, as I'll come on to, Mr. Wilson made a formal application for an adjournment that came before Mr. Justice Spencer. This is how coronavirus entered the frame. In commendably brief submissions, and make of that what you will, Mr. Wilson's advocate advanced the following argument. 2 days after Mrs. Justice Stein had rejected his request for adjournment, Mr. Wilson had unfortunately come into contact with someone who was COVID-19 positive. This required him to self-isolate, and as a result, he could not attend court. No problem. Couldn't he attend a remote hearing? No, he couldn't attend a remote hearing because it was alleged that he was profoundly deaf and therefore unable to effectively take part in a remote hearing. So as Mr. Wilson could not attend in person, and as he couldn't attend a remote hearing, it was suggested that the currently listed hybrid hearing would need to be adjourned until his period of self-isolation had ended. What did Ashford have to say about that? Well, in contrast to the commendably brief submissions of Mr. Wilson's advocate, Ashford made several points, and for our purposes, those which are listed on the PowerPoint are the most relevant. Ashford pointed out that there was no medical evidence to confirm Mr. Wilson's apparent deafness. So again, we've got reference to the need for medical evidence. Pointed out that there was no real evidence confirming Mr. Wilson's need to self-isolate. And also mentioned, specific to this case, that as the matter was proceeding by Part 8, there would be no live evidence, and Mr. Wilson's attendance would therefore not strictly be required, or rather his participation would be minimal in any event. There were also, I should say, the usual appeals to the interests of justice as to keeping to hearing dates and finalising interim injunctions. Now, given the emphasis in VTB Bank on medical evidence, you might think things were not looking particularly good for Mr. Wilson. And here you would be right. The application does not even get off the ground, according to Mr. Justice Spencer. If you have a few minutes after this talk, I do highly recommend that you read paragraphs 18 to 22 of this judgment. Mr. Justice Spencer is excoriating of the arguments made by Mr. Wilson. He found it an extraordinary coincidence that Mr. Wilson had come into contact with a COVID positive person 2 days after his request for an adjournment had been refused. And in what might be considered a rather mild use of the word, he was skeptical of all that. Importantly, though, he also found that there was no medical evidence in support of Mr. Wilson's apparent deafness, and consequently no proper medical basis for why a remote hearing couldn't take place fairly. So as before, what can we deduce from all of this? Well, again, evidence is crucial. Whereas medical evidence was essential to Mr. Medjlemine's success in VTB Bank, it proved lethal to Mr. Wilson. But I'd say note also that Mr. Justice Spencer was not simply prepared to accept reference to COVID as a cure-all. He considers forensically the evidence and arguments advanced by Mr. Wilson, or indeed the lack of it, and it suggests, in my opinion, that the courts are becoming increasingly wary of nebulous appeals to the pandemic as a panacea for non-compliance. And bearing that in mind, we move to the third of the three cases, which is Finvest. For present purposes, all we need to know is this. His Honour Judge Pelling QC had ordered Mr. Hollyoake, the second claimant, to provide further information by the 24th of February 2021 on penalty of strikeout. It was an unless order. Mr. Hollyoake failed to do so, and accordingly, a relief from sanctions application was made. How has COVID impacted on this? Well, it was alleged by Mr. Hollyoake that in tandem with some family issues he was facing at the time, his infection with coronavirus had prevented him from properly conducting the litigation, and cumulatively, these were a good reason for setting aside the strikeout. And of course, Mr. Lovering, the defendant, was vehemently opposed. Again, he refers to the lack of objective evidence in support of Mr. Hollyoake's apparent COVID infection, or indeed its effect upon him, and noted that in any event, Mr. Hollyoake was a man of substantial means, with a team of employees and professional advisors who could have ensured his compliance with his Honour Judge Pelling QC's order. And I pause there to say it's interesting to note that this point as to means, employees and advisors was not raised in VTB Bank about Mr. Medjlemayan, who presumably was also a man of considerable means. And you would be forgiven for thinking, as I did, that the lack of medical evidence put forward by Mr. Hollyoake would be fatal. It was not. His Honour Judge Pelling QC concluded that where one is concerned with an allegation of COVID infection, the court will generally take a rather more benevolent attitude towards proof than in the case of other medical ailments. And as can be seen by the quote from paragraph 41, emphasis was placed on the presence of a witness statement from Mr. Hollyoake confirming his infection. It's also interesting to note that the court considered the cumulative effects of family issues and the coronavirus infection to be potentially good reasons for explaining a delay. So what are we to make of all of that? Well, as to evidence, those eagle-eyed amongst you will notice that here I've placed not an exclamation mark after the word evidence, but a somewhat more bashful question mark. And that's because in my rather humble opinion of a decision made by a particularly eminent High Court judge, this is rather surprising. What was important to His Honour Judge Pelling QC, but not referred to in the quoted text from the previous slide, was his belief that obtaining medical reports to support a COVID infection was a rather difficult endeavour. And it seems to me that while that may be, there is a wealth of evidence that can be exhibited in support of a COVID infection, from screenshots of text messages from NHS England, app messages as well, to copies of test results. And indeed, all of us present can now avail ourselves of free lateral flow tests from the government. It's not clear whether any of that evidence was exhibited to Mr. Hollyoake's statement, but it certainly seems to me that there is a wealth of easily obtainable objective evidence to substantiate a claim of COVID infection that really should be exhibited if you're going to argue that your client has been exposed or infected. And additionally, point two, although each case on relief will of course turn on its own facts, it's worth noting that the court's put down a marker here. That marker is that a COVID infection, cumulative with domestic and familial problems, might amount to a good reason for a breach. So broadly then, what do these three cases show? Well, notwithstanding Finvest, the last case that we looked at, it certainly seems plain to me that the courts will expect evidence substantiating a COVID infection and its effects. And that last part on effects is crucial because, of course, many of those infected with COVID will be asymptomatic. So if you are advancing an argument based on COVID, you must come armed with evidence. And if you are responding to an argument based on COVID, you must point out any deficiencies in that evidence. So that's point one. Point two, and as will be plain from Ashford in particular, the courts are, it seems to me, becoming increasingly wary of nebulous appeals to the coronavirus as a panacea for non-compliance. And certainly in my practice, and I would wager probably in yours too, it seems that the initial leeway that might have been given to litigants allegedly impacted by the pandemic has begun to shrink and narrow. The courts, it seems, are hardening. And it certainly seems to me that reference to the pandemic alone will just not cut it anymore in the way that it might have done last year. Much of this is common sense, and it should be. It shouldn't come as a surprise, but certainly as ever, arguments based on common sense do seem a little bit more sound when they're supported by high court authority. I'll conclude there, but point out that in my preparation for this talk last night, a colleague of mine pointed me to another recent decision, Boxwood and Gleeson, that was handed down 3 days ago, in which Mrs. Justice O'Farrell looked at whether or not the closure of a solicitor's office in response to the pandemic provided a good reason for failing to serve a claim form on time. The conclusion was it did not, and that conclusion can be found at paragraph 56. How that relates to the previous case that we had looked at, it is a matter, of course, for your own practices, but all 4 cases will be sent at the conclusion of this talk. I can see that a number of questions were asked. David, I'll hand back over to you.
Thank you very much, and thank you very much indeed, Jack. And yes, you're absolutely right. We've got just about a few minutes to discuss some of the questions that we've received. And thank you all for submitting questions. Some of you submitted questions in advance, and we've been getting questions in the chat. So let's start. I think we had some questions that we had in advance, which I'll just read out first of all. That we had a question concerning whether it would be practical to make wholesale changes to primary legislation. This is, I think, probably really to do with the EU directives and consumer rights. So maybe the Richards had an opportunity just to consider that, and also, as he mentioned briefly in his talk, the Jesse Prin's question concerning UK accession to the Lugano Convention. So Richard, I don't know whether you want to just make a comment or two about that.
Yes, I will do. So the first question was whether it would be practical or necessarily preferable to make wholesale changes to primary legislation. And is it anticipated that there will be changes or rewrites of legislation created under EU directives, so the Consumer Rights Act? As I said during the talk, I think there is a power to do that, but as the question identifies, I don't think they'll be made unnecessarily. I don't think, for example, the reference to the Consumer Rights Act, there is a particular need for any change to be made in this case. Changes will be made to make sure that acts operate effectively in domestic law. So they're not going to affect your probably day-to-day use of those types of legislation. And then the second question that we had in advance was in relation to our views on the UK's accession to the Lugano Convention. I can see in the question and answers box as well, I think we've had another 3 or 4 questions about that. It is very topical at the moment. As I said at the start, I was checking each day leading up to this talk to see whether we were going to get any more news about it. The position is essentially, in terms of the convention, there needs to be unanimous approval. So there's already support from Iceland, Norway and Switzerland. And it's the EU where there's the issue at the moment. I think it was the 12th of April, 2021, the European Commission, it was reported in the news, blocked the UK's accession to the convention. I'm not sure it was that final, or it certainly isn't final. The EU Commission's decision isn't final. Someone's asked a question about how that decision will be made, and I think they are right that it probably will be a qualified majority in the European Council. From doing some reading around this, and I'm not sure how these people knew, but apparently France is currently very much opposed, and Germany's sitting on the fence. And the EU said a decision will be made over the next few weeks, and that was on the 12th of April. So within the next week or two. I think the position is uncertain. I hope that we do join the convention. I think it would make things much more straightforward. Hopefully there's enough pressure from Iceland, Norway and Switzerland saying that the UK should, and that they consent, that will help. But it's difficult to say with any certainty at the moment.
Okay, thank you very much indeed. I know we've had a question from Janine Akhtar, which I'm going to just pose to Jack, because she's talking about mediation and whether in the context of the pandemic affected cases there is been any attempt to engage in mediation. And generally, I think that you, Jack, are an accredited mediator, so maybe a good thing for you to pick up from that question.
Yes, absolutely, and brilliant plug as well, if I may say so, David. It's not clear, basically, Janine, whether or not mediation was attempted. So I'm afraid I sort of have to dodge that question. To the extent I can answer it, I'd say it certainly seems to me that mediation should have been engaged in. I think I'd be surprised if mediation hadn't been attempted, at least in the case of Ashford and Wilson, although you'll note that Mr. Wilson was certainly described as a particularly hostile litigant, so maybe that was torpedoed if it was proposed. In the question of Finvest and Lovering, seems to me that was a matter that was ripe for mediation too. I also think mediation ought to have been pursued in VTB Bank, though given that Mr. Mechlemayan had issued proceedings in Armenia and VTB Bank sought to immediately prevent the enforcement of those proceedings, I think the immediacy would have prevented mediation from being a practical solution. So short answer is I don't know, but those are certainly my opinions on whether or not mediation ought to have been pursued or was practical. I hope that's of some assistance.
Yeah, thank you very much indeed, Jack. We've got time perhaps for one more question. We had a question from L. Smith, who is a visiting lecturer at the University of Law, asking about whether or not the pandemic requires legislators to think of new methods of enforcement and to grant the courts greater powers for engagement with institutions in order to provide more robust solutions in the context of social distancing and increasing economic decline. So there's quite a lot there, which I think cuts across probably both of you. So can I have some brief comments from each of you before I wind things up, and just thank everybody and in my closing. So Richard, do you have any view on the point that's been raised there?
I thought that probably it was more something for Jack.
Yeah.
I'm not sure how much it would apply to the areas that I was doing.
Well, speaking for myself, Richard, obviously what's been identified there is the changed reality that we're going to go through a period potentially of economic decline, that social distancing is probably not going to be reversed immediately. And I would imagine that many of the things that we've seen, protocols for dealing with things procedurally, are going to continue to inform the way in which civil justice develops, both procedurally and substantively. And I suppose what's being asked is if you've got your crystal ball there just to gaze into it and give us any wisdom you might have.
Well, I think apart from the specific changes that I detailed, the courts are generally trying to carry on with business as usual. I know the courts are generally trying to open things back up and dealing with things in a similar type of way to the way they have been up until this point. I know that I think throughout late May and June, the courts are going to start to get people back into the courts rather than dealing with things remotely. So from looking at things in that way, I think it's just, there will be these changes going on, but as far as we're concerned, I think things will continue in the same fashion.
Yes. And just finally, before whilst I still have you there, you'll see that Andrew Wesson, who's a regular at our events, has written quite a detailed question concerning the Civil Jurisdiction Judgments Act. I think much of it may have been covered by your talk, but no doubt you'll be able to catch up with him if necessary after this event, because we will try and answer those questions that we've not answered specifically in our chat or in the presentation itself. So I'm sure you'll reach out to Andrew Wesson in due course. Thank you very much. And finally, over to you, Jack. Any final thoughts on the future as was anticipated in that question?
Well, I certainly think nothing bad can come of considering the point further. I think that's the first point. Certainly, we've seen in the residential landlord and tenant sphere steps taken to restrict remedies and also to restrict enforcement. So the courts are being told to adopt certain measures in response to coronavirus from a residential L&T perspective. As to the practicalities of enforcement and whether or not legislation for social distancing ought to be introduced, I'm not convinced it's necessary, though perhaps a case can be made. And the reason I'm not convinced is for the last year and a half, of course, we've all been living with social distancing and we've all been aware of this horrible virus. And so I suspect we're all well versed in the basics. And I suspect we've all got the hands, space, face, etc. phrases at the forefront of our mind. So whether that needs to be put into legislation for enforcement purposes, I'm not so sure, but I certainly think it's a matter that would not be hindered from further discussion.
Thank you very much indeed. So it just remains for me, first of all, to make a few thank yous. Thank you, first of all, to our excellent presenters, to Richard Whitehouse and to Jack Webb for their talks, which I hope you found insightful and relevant. We look forward to seeing you all on future occasions. I'd like to thank Delphine Avondo, our marketing manager, who's based in Bristol, for all the work she's done in terms of making this talk available and making this webinar such a success. I'd like to thank Lisa Watts, our marketing consultant, for the help she gave with the slide designs and generally with the quality of the presentation. And finally, I'd like to thank David Fielder, the practice director, who introduced matters at the beginning of the talk. He is ultimately the business end of this matter, and you'll find him on our website, and he'll be happy to discuss with you the services of 3PB should you require them in the future. Thank you very much indeed to the audience for being so attentive, for supporting us, and for providing the questions that have clearly peppered this talk. And we look forward to welcoming you on future occasions to the 3PB webinars. Wish you all a very good afternoon.